Hello friends, myself Deepak Gupta, again signing in today on this platform of CollegeDekho.com, specialized portal for college students. And today we will be taking on one of the topics of the corporate law related to the Memorandum of Association and Articles of Association, known as Doctrine of Constructive Notice. As we have already discussed the doctrine of corporate weal. We have already discussed the doctrine of ultra wires. So primarily there are four kind of doctrines. Two we have already discussed. Third is today underway, and then we will have one more session on the doctrine of indoor management. And as I have discussed earlier also, all these doctrines are in a way related. And how is that? That when I discuss the doctrine of corporate weal with the help of the case Solomon versus Solomon and Company Limited, I stressed on the fact that by this decision and as per the corporate law, this doctrine implies that any incorporated company, though is owned by the shareholders, though is created by the promoter, though is managed by the board of directors, though is owned by the equity shareholders, but still it is a separate legal entity from all the three. The promoter may be the father, but promoter has no similarity with the company. It means promoter कंपनी का फादर हो सकता है, बट कंपनी के assets कंपनी के हैं, promoter के नहीं हैं. Shareholders company के owner हो सकते हैं, but they are not the owners of the company's assets, and hence they are not liable for the liability of the companies. And board of directors, they are just the agents of the company to work on behalf of the company as appointed by the shareholders. So simply speaking, the doctrine of corporate weal, what it did, that it underlined that the company and the shareholders are separate. Then we moved on with the concept of doctrine ultra vires, where we stressed that because company is a legal person, that is, it has to work through its agents, the human agents, normally known as the directors, and therefore there has to be a code, predefined code, and the rules and regulations which are to be followed. So company will always have two primary documents, that is the memorandum of association and articles of association. And I stressed that memorandum of association is like the constitution of the company, and the articles of association, they are like the rules and regulations of the company, the rules and regulations of the company. And therefore whatever is written in the memorandum is what the company can do. So we stressed that whatever is written in the objects clause is what the company can do, and articles of association define the rules and regulations which are to be followed in achieving those objects. And we also stressed that these memorandum or articles will specify the objects, that is, they will specify what the company can do. They will not specify what the company cannot do. Therefore, the doctrine of ultra wires implied, that is why the word doctrine, that it implied indirectly that because the company can do only what is written or covered under the object clause, therefore any act which is not covered by the object clause and if done by the company will be illegal, will be non-binding on the company, not by any express provision, but by the doctrine of ultra wires. And in the same way, and on the same path or doctrine of ultra wires, we also have to understand the doctrine of constructive notice. Now, what is that? So, before we understand this doctrine of constructive notice, we have already understood the meaning of the word doctrine, but there are other two words, notice and constructive. So once we understand these meaning, then this doctrine will itself fall into place of understanding. What I am trying to say that simply speaking, notice क्या है? To make others known. मतलब आप किसी भी फैक्ट के बारे में किसी को बता रहे हैं, आपने किसी के खिलाफ कोर्ट में केस किया तो आप चाहते हो कि भाई वो कोर्ट में आए, तो कोर्ट या आप उसे नोटिस भेजेंगे। तो अगर आप ऑलरेडी केस फाइल कर चुके हो तो कोर्ट से समन जाएगा, नोटिस जाएगा। और अगर आपने किसी के खिलाफ लीगल एक्शन लेना है एंड यू वांट टू वार्न हिम, देन यू फर्स्ट गिव अ नोटिस दैट इफ यू डोंट सेटल दिस थिंग देन आई विल गो टू द कोर्ट। So you are making note, you're making understand, you're making known to other person what you're going to do. That is the normal word meaning of the word notice. Sorry. And when we make this notice can either be express notice or implied notice. So when we use this word implied notice, then this implied is actually denoting the constructive. तो एक्सप्रेस इज दैट यू आर मेकिंग एन एक्सप्रेस एक्शन टू मेक इट नो। तो एक्सप्रेस में आपने किसी को मुंह से बोल दिया भाई मैं काम करूंगा, तो ओरल नोटिस हो सकता है। लिख के भेज दिया तो रिटर्न नोटिस हो सकता है। यानी कि वन वे और दी अदर यू आर मेकिंग एन एफर्ट टू मेक अ नोटिस। when you don't have to make it, you don't have to do any express efforts or action or either orally or physically or written to make know certain fact to the other person, it is by default to be done. Means you are not making any express effort, but still the other person is presumed to know. Then we use the word constructive notice. So what the point is that you are not making an express provision, but the other person is deemed to know of the fact. Irrespective of the fact कि उसको पता है कि नहीं पता है, लेकिन उसको पता होना चाहिए। एक छोटा सा एग्जाम्पल मैं समझाता हूँ आपको जिससे कि ये वर्ड क्लियर हो जाए। हाँ, ड्राइविंग के कुछ रूल्स हैं। तो ड्राइविंग के कुछ रूल्स हैं विच आर कवर्ड अंडर मोटर व्हीकल एक्ट, एंड दिस मोटर व्हीकल एक्ट इज अ पब्लिक डॉक्यूमेंट। Anybody can access either through the public gazette or he can buy from the market and then he can read. So it's a public document. It presumes that everyone is deemed to know of its content. Now when I say deemed to know, I'm not underlining कि सबको पता होना चाहिए. We are referring to those persons who are having a license. So if I have a license to drive a particular vehicle, then I am presumed to know all the rules as per Motor Vehicles Act that I should follow while driving on the Indian roads. While driving on the Indian roads. So when you go for a license test, they ask you certain questions about this. तो अगर लाइसेंस लेने गए और वहाँ रिटर्न टेस्ट है, तो रिटर्न टेस्ट में वो आपसे उस लॉ के बारे में पूछने का भी लॉ पता है कि नहीं पता है। और अगर ये ओरली पूछा तो भी ठीक है, और अगर नहीं भी पूछा तो इट डज नॉट मीन दैट यू कैन से कि पूछा नहीं था तो मुझे लॉ के बारे में पता नहीं है। आपको अगर लाइसेंस मिल गया है देन इट मीन्स यू आर known, you are clearly known about all the laws of the Motor Vehicle Act which are applicable for the tribe. So irrespective of the fact कि आपने वो पढ़ा है कि नहीं पढ़ा है, you are deemed to know. That is, you are having a constructive notice of the fact. तो अगर आपने ड्राइविंग करते हुए कोई रूल डिसोबे कर दिया और आपका चालान कटने वाला है, देन यू कैन नॉट क्लेम इनोसेंस ऑफ द फैक्ट कि सर मुझे पता नहीं था। आपको पता हो चाहे ना पता हो, यू आर प्रेज्यूम टू नो, यू आर डीम टू हैव अ कंस्ट्रक्टिव नोटिस ऑफ द फैक्ट एंड हेंस यू आर चालान फॉर इंटेंशनल ब्रेक ऑफ द लॉ। On the same lines, when we come to the company, so what is happening with the company, that because company is a legal person, it has to work as per the provisions of the MOA and AOA. And both these documents are public documents, which you can always go to the registered office of the company to study, and you can take it home by paying a requisite or nominal fees. So when there is a contract between a company and a person, third person, there is a contract when they are entering into a contract. सो कंपनी का एमओए होता है, ये इस पर्सन को पता होना चाहिए, नहीं पता तो इसकी गलती है पर्सन की। इसका एक एओए होता है, ये उसको पता होना चाहिए। एमओए के अंदर ऑब्जेक्ट्स है, कॉन्स्टिट्यूशन है, ये बात उसको पता होनी चाहिए। वो काम होगा कैसे, उसके रूल्स एंड रेगुलेशन उसको पता होने चाहिए, ठीक, बिकॉज दे आर पब्लिक डॉक्यूमेंट। तो अगर पर्सन ने इनको पढ़ा तो पता है, और अगर नहीं पता तो गलती इस पर्सन की है, बिकॉज irrespective of the fact whether he has studied the MOA or the not, he is presumed to have known the contents of the MOA and the AOA. So a person is deemed to have a constructive notice of MOA and AOA. Therefore, when he enters into the contract, which is covered by the memorandum, then the contract is valid, there is no default. But if he enters into a agreement which is not covered by the object clause of the company, then the fault does not lie with the company, but the person is itself responsible for the default because of the doctrine of constructive notice. He is presumed to know the content, and by the doctrine of ultra wires, he is presumed to know that whatever is not covered by the memorandum or articles is ultra wire, that is illegal. Therefore, these two doctrines together put all onus, all responsibilities, all onus on the outside. उस आउटसाइडर की जिम्मेदारी है, and therefore in a way they are beneficial for the company and in a way negative for the outsider because सारी की सारी responsibility उसकी है. Now first look when this looks negative, but it is genuine because company is a legal person. एंड व्हेन हम लोग, अगर एक पर्सन अपने गले पे लिख के, माथे पे लिख के घूम रहा है कि भैया मैं पागल हूँ, मेरे से डील मत करो, हाँ, और तब भी आप उससे डील कर रहे हो, तो गलती उसकी थोड़ी है। वो तो कह रहा भाई मैंने लिखा हुआ है यहाँ पे, आपको दिख क्यों नहीं रहा, ठीक। तो इन अ वे, तो अगर आप किसी शॉप पे घुसे, शॉप के ऊपर बोर्ड लगा हुआ है दैट वी आर अ हार्डवेयर स्टोर, तो लिखा हुआ है शॉप का नाम कि गुप्ता हार्डवेयर स्टोर, एंड समवन एंटर्स एंड कहता भाई साहब फूल दे दो, कहता भाई साहब अकल नहीं है क्या आपको कि आपका लिखा हुआ हार्डवेयर स्टोर है, हाउ विल यू गेट द फ्लावर्स? It means that notice, that is the board on the shop, specifies what they are dealing. It's a public display, and therefore is third party enters and asks something which is not covered by the board, then he is at fault. He is to face the consequences. On the same lines, when someone enters into a contract with the company, तो कंपनी का नाम, कंपनी के ऑब्जेक्ट, कंपनी का रजिस्टर्ड ऑफिस, इस सब की इंफॉर्मेशन कंपनी अपने आप से बोलने की जरूरत नहीं है, क्योंकि वो सारी की सारी कहाँ लिखी हुई है, मेमोरेंडम में, एंड एनीबडी कैन मेक इट अंडरस्टैंड. सो irrespective of the fact whether he reads it or not, he is presumed to know that he knows it. That is what you call the doctrine of constructive notice. So आप प्लीज नोटिस करिए कि तीनों के तीनों डॉक्ट्राइन्स सीक्वेंस में आपको बताई गई हैं. तो डॉक्ट्राइन ऑफ कॉरपोरेट व्हील ने कंपनी को सेपरेटली इंटरप्रेट किया, सेपरेटली प्लेस किया फ्रॉम द ओनर्स. डॉक्ट्राइन ऑफ अल्ट्रा वायर्स ने साफ साफ बोल दिया कि भाई मेमोरेंडम में क्या होगा, आर्टिकल्स में क्या होगा, और अगर उसमें कुछ नहीं लिखा हुआ है तो वो लीगल है, बियॉन्ड पावर्स है, प्लीज टेक द केयर. और डॉक्ट्राइन ऑफ कंस्ट्रक्टिव नोटिस ने ये भी बोल दिया कि क्योंकि ये दोनों के दोनों डॉक्यूमेंट्स जो हैं वो पब्लिक डॉक्यूमेंट हैं, तो आप उसे रीड करो ना करो, यू मस्ट बी प्रज्यूम्ड टू हैव नोन of the fact देयरफॉर इन तीनों चीज़ों से एक बात बड़ी सिंपली समराइज होती है कि कोई भी थर्ड पार्टी, एनी थर्ड पार्टी हु इज विलिंग to enter into any contract with the company, any contract with the company must must read and understand its MOA and AOA. ठीक है? Otherwise, such third party is responsible for any defaults, even made by a company, even made by company. ठीक है सर, आई थिंक आई एम क्लियर विद दैट. नाउ वन ऑफ वेरी इंपॉर्टेंट ऑब्जर्वेशन ऑफ दिस डॉक्ट्राइन इज दैट, ये अभी हमने इन डॉक्ट्राइन्स में क्या बोला कि भाई एक तरफ तो कंपनी थी, मैं उसको लिख रहा हूँ लिमिटेड, क्योंकि इंडिया में कंपनी का नाम लिमिटेड से एंड होगा, और एक तरफ वो पर्सन है, वो थर्ड पर्सन है जो कंपनी के साथ डील कर रहा है. अब जो इन दोनों के बीच में एग्रीमेंट हुआ, एग्रीमेंट हमेशा टू वे है, एक ने ऑफर दिया, एक ने एक्सेप्टेंस करी, तो इन दोनों के बीच में जो भी ये एग्रीमेंट यानी कि कॉन्ट्रैक्ट एंटर हुआ, ठीक है, उस कॉन्ट्रैक्ट के अंदर इस थर्ड पर्सन ने कंपनी को कुछ गुड्स प्रोवाइड कराए, और जब बारी आई पेमेंट की, तो पेमेंट वाज डिफॉल्टेड बिकॉज अ न्यू डायरेक्टर came into the play, and he said that this agreement, this contract is ultra wires, that is beyond the object clause of the company, and therefore he has the authority to stop it, and therefore the contract was stopped and the payment was denied. Now this person, instead of going to the court for the payment, said okay, but just give my goods back. जब कॉन्ट्रैक्ट नहीं कर रहे तो मेरे गुड्स वापस कर दो. तो कैन दिस कंपनी डिनाई, the question is, can this company deny the withdrawal of goods by this third person on the grounds of the total agreement being ultra vires? So answer is no, because this company cannot deny the withdrawal of the goods provided by such third person, because as the initial contract was ultra vires, that is beyond any legal obligation, therefore these goods provided by the third person are actually not belonging, they do not belong to this company. तो इन अ वे जिस बेसिस पर ये कॉन्ट्रैक्ट आए थे, अगर वो कॉन्ट्रैक्ट ही अल्ट्रा वायर्स हो गया, इलीगल हो गया, तो ये गुड्स कभी इस कंपनी के हुए ही नहीं. That is, these goods never belong to the company, and because they never belong to the company, therefore they have no right for its possession, and therefore this third person can always claim that back. तो इस डॉक्ट्राइन ऑफ कंस्ट्रक्टिव नोटिस और अल्ट्रा वायर्स को इकट्ठे रीड करना पड़ता है, जिससे नुकसान सारा थर्ड पर्सन का हुआ, लेकिन एक पॉजिटिव साइड ये है कि अगर इस तरह की गुड्स प्रोवाइड करे हैं, तो उन गुड्स के ऊपर उस कंपनी का कोई हक नहीं होगा, and they can always be claimed back by such third person on the grounds of the doctrine of ultra wires. तो अगर डॉक्ट्राइन ऑफ कंस्ट्रक्टिव नोटिस कंपनी के फेवर में भी काम कर रही है, अल्ट्रा वायर्स कहीं ना कहीं ये भी एश्योर कर रही है कि जो चीज़ आपकी नहीं है वो आप रख नहीं सकते, क्योंकि जिस कॉन्ट्रैक्ट के बेसिस पर आपने लिया है दैट वाज अल्ट्रा वायर्स. So there are such a beautiful implications of the corporate law which are important for both the company and the third person, but third person has to be more vigilant. Now the fourth implied doctrine is doctrine of indoor management, जिसकी डिस्कशन हम लोग डिटेल में अगले सेशन में करेंगे. बट इस सेशन में जस्ट ऑन इन दिस सेशन, जस्ट for your knowledge, that we are noticing that whether it is a doctrine of corporate will, whether it is a doctrine of constructive notice, whether it's a doctrine of ultra wires, they all are basically in favor. They all are basically in favor of the company. So the outsider feels a bit awkward कि भाई सारी की सारी डॉक्ट्राइन्स तो आपने कंपनी के फेवर में डली हुई है, यानी कि सारा का सारा लॉ जो है वो कंपनी को सपोर्ट कर रहा है. तो जो थर्ड पर्सन है, जो इंडिविजुअल पार्टी है, इट फील्स अ लिटिल डिच्ड. फॉर एग्जाम्पल फॉर एग्जाम्पल कि इस कंपनी जिसको हमने लिमिटेड बोला और उस थर्ड पर्सन के बीच में जो एग्रीमेंट हुआ, दैट वाज इंट्रा वायर्स, मतलब ऑब्जेक्ट क्लॉज से कवर्ड था. इट मीन्स मेमोरेंडम वाज नॉट डिफॉल्टेड and there were so many rules and regulations. So for example, one of those rules and regulations said that when you enter into such kind of contract, you need to pass a special resolution. Now, when this contract was entered into, the director signed as per the requirement of the articles, but the special resolution, which was presumed to be passed before such signing of contract, was not passed, and they decided that they will take the meeting later. And therefore, even without passing this special resolution, they signed the agreement and the contract was created. But later on, someone came to realize that this resolution was not passed. So the any person on behalf of the company claimed, gave notice to that third person that because we have defaulted, the company has defaulted, or the previous directors have defaulted on the passing of such a special resolution, therefore your contract is not valid. Now, this is a real problem for the third party, because as a third party, we can know what is to be covered by the memorandum. We can know what is the procedure to be done, but we cannot know whether it has been done or not, because we are not internal to the company. And because we are not internal to the company, I'm saying because we are not internal to the company, therefore, we are not presumed to know that whether these internal formalities have been completed or not. So we are presumed, we are allowed, as a third party, we are allowed to presume that all internal formalities have been complied with. So we are just to know what is to be done. But whether it has been done properly or not is not our cup of tea, and we are presumed to know that all internal management, or I should say the indoor management procedures, have been complied with. And even if they are not complied, then they are the fault of the company, and the liability, responsibility will fall on the company and not on us. So this doctrine of indoor management is the only silver lining in favor of the third parties, where the responsibility of knowing whether the internal procedure have been fulfilled or not is to be ascertained, is to be fallen on the company, and the third party is not responsible for the indoor management. So no contract which was intra vires the memorandum will be deemed ultra vires just on the ground that there was a default in the indoor management. So indoor management allows a third party to presume. So this concept of law was ascertained in the leading case of Mr. Turkan. He had a case with the company, and in that case it was settled that indoor management is to be ascertained with the company, not with third person. That is why it is also known as the Turkan's law. So Turkan's law और इंडोर मैनेजमेंट, इन चारों में से जो डॉक्ट्राइन ऑफ इंडोर मैनेजमेंट है, this is the only silver lining, this is the only thing in favor of third party. So therefore all these four doctrines have to be understood properly, with the only crucial point to understand that there are certain exceptions of the Turkan law. That is, only in some cases there is a chance, only in some cases there is a chance that the assumption whether the indoor management has been done properly or not is also revocable. For example, अगर मुझे पता है I am a third party entering into the contract with the company and I knew specifically that this was to be done and the company has not done it, the company has not done it, and even though entering into a contract, तो अगर मुझे पता है कि कंपनी जानबूझ कर डिफॉल्ट करके ये कॉन्ट्रैक्ट एंटर कर रही है, तो एज ए नॉर्मल पर्सन आई शुड बी रेजिंग द वॉइस एंड आई शुड नॉट बी एक्सेप्टिंग सच अ कॉन्ट्रैक्ट. But if I just give a deaf ear, I ignore such anomaly on behalf of the company, then how can I play the victim later? So if the person who is claiming the benefit of indoor management is knowing of the default in the beginning of the contract, then he cannot claim the benefit of doctrine of indoor management. So we can say that there are certain cases where the indoor management can be ignored. Otherwise, indoor management provides protection to the third party regarding the procedure, internal procedure which the company is expected to follow. See? So I hope we are able to clear you all these four doctrines, and we will hope to see you again on this platform of collegedekho.com tomorrow also. Thank you very much. This is Deepak Gupta signing off from this platform of